Hey everyone, Rob Ryder, Thursday, September 20th, 2012. My email address is courtofrecord at AOL.com. And thank you. I'm still in the house. All of you that contributed, I am most appreciated. Thank you very much. Still looking for justice, which is really the proper administration of laws. And in jurisprudence, the constant and perpetual disposition of legal matters or disputes to render every man his due. That'd be really nice to find justice as a noun title given to judges. And a judge is an officer so named in his commission who presides in some court. Semicolon. So, it's an officer who presides in some court. Could be a public officer. Now, I don't know how many of those there are because the oaths I've seen of public officers aren't the one prescribed in the Constitution. If it isn't what's in the Constitution, they didn't take a public oath. They've taken an oath, but they haven't taken a public office oath, so they're not holding a public office. And also then appointed to preside and administer the law in a court of justice. Okay, well that's good too. Let's find that guy. So, interesting things last few weeks. I've been looking a lot at canon law, of all things. And spent a lot of time on a site called the New Advent, Newadvent, newadvent.org. It's a Catholic encyclopedia online, and when you put a word in there, you usually get a very long definition. That's why it's taken me a while to get this information out. Spent the last 10 days reading. So if you put in, for instance, laity, right? You get an 8-page definition of what laity is. Put in ecclesiastic court, long definitions. So there's lots to be seen there, and the nice thing is it's all tied to scriptures. They usually reference where they're making their presumption from based on scripture. Always a good thing. And so, as it's wrong to judge somebody without examining the facts, I decided to go examine the facts. I've had my feelings about the church also. I was born Catholic. Hell, I was an altar boy. Got disenchanted and left. And then, now you think about, why is it we have these feelings about churches? Is it because somebody wants us to feel that way? Well, who would they be? Well, they could be them. So, here's some interesting things I found. Let's just start here. So, in Book 7 of the Code of Canon Law, it's on the processes used in a trial. And just quickly some things out of here. I only got an hour to do this. I'm going to have to kind of rush. The church has its own exclusive right to judge cases which refer to matters which are spiritual or linked with the spiritual, the violation of ecclesiastic laws, and whatever contains an element of sin. And really what sin is, it's a transgression of God's law. To determine guilt and impose ecclesiastic penalties. All tribunals of the church are governed by the canons which follow without prejudice to the norms of the tribunals or the apostolic see. That's interesting. So the first see is judged by no one. I don't know what they mean, the Pope, but let's say the Pope. In cases mentioned in another one, the Roman Pontiff alone has the right to judge heads of state. Well, I want to try to figure out how to use that. Not quite there yet, right? Baby steps. So the tribunal of the first instance is in each diocese, and for all cases which are not expressly accepted in law, the judge of the first instance is the diocesan bishop. He can exercise his judicial power either personally or through others in accordance with the following canons. If the case concerns the rights or temporal goods of a juridical person represented by the bishop, the appeal tribunal is the judge of the first instance. It sounds like I can use him to represent me to go get my stuff. Right? We say that the church has everything, right? That everything is run by Rome, and it absolutely is. Where we used to have civil governments, now they're all ecclesiastic societies, and they've all taken oaths. And they put them all under the jurisdiction of the church. Each diocesan bishop is obliged to appoint a judicial vicar or officials with ordinary power to judge. The judicial vicar is to be a person distinct from the vicar general, unless the smallest of the diocese and limited number of cases suggest otherwise. The important thing here is, if you're taking something to the church, the judge of the first instance is the bishop. And when you look at doing a petition, that's who it says to send it to. I think that was really all I had in here. Yeah. I'll send this along, but this is just off of canon law. If you were to Google Code of Canon Law, you'll find this stuff. But they do have a guy called the Promoter of Justice. That's always wonderful. And they also got notaries. We're going to find out how powerful that is. So, do you want to say? Yeah, I do. So what I did is I did a Reader's Digest version of a whole bunch of things I had read on New Advent, and I'm going to kind of skim through these. When I send this out, I'll send out this Reader's Digest version, and then all the pages I copied and pasted. But all this is coming off of New Advent website. It's nothing I've done special. You can go there and look at it yourself. You can copy it. You can paste it, you can make it bigger, you can split it apart, you can go look for definitions, you can do with it whatever you want. Influence of the church on civil law. Christianity is essentially an ethical religion, and although its moral principles were meant directly for the elevation of the individual, still they could not fail to exercise a powerful influence on such public institutions as law, the crystallized rule of human conduct. The law of Rome escaped this influence to a large extent because much of it was compiled before Christianity was recognized by the public authorities. So first of all, Christianity has been recognized by the public authorities, but the laws of Rome were already written before that. So according to Roman law and usage, a slave was considered not a human being, but a chattel, over which master had most absolute control up to the point of inflicting death. Emperor Justinian gave to freed persons the full rank and rights of Roman citizens and abolished the penalty and condemnation to servitude. In other words, got rid of the slaves. Now, Justinian was, he converted to being a Catholic. And as we'll see, Catholics got a definition we should all pay attention to and quit thinking we know everything based on a word. According to provisions of Roman law, a man who was forcibly ejected from his property could, in order to recover it, apply the process known as, whatever it is, against the one who ejected him, directly or indirectly, against him who perpetrated the act of ejection and consoled it. But he could take action against the heirs of those who ejected him only insofar as they enriched by spoliation, and not against a third owner, who meanwhile had obtained possession of his former property. So if a third owner got your property, there wasn't much you could do about it. Somebody come take your shit. You can go after heirs for the spoils, I guess, whatever that means. But if they transferred it to a third party and sold it, you were out of luck. Canon law modified this unfair measure by decreeing that he who was despoiled of his property could insist first on being reinstated. We're talking about your estate, your body, and your landed estate, your all capital letter name, and all its accounts. If the matter were brought to the courts, ain't much they can do unless you bring it to him. He could allege the fact of spoliation, and finally he was permitted to have recourse to the law against the third owner who had acquired the property with knowledge of its unjust origin. The Roman law admitted the right of prescription in favor of him who had been in good faith only at the beginning of his possession, and it abstracted altogether from the good or bad faith in either party to a civil action if it were terminated by prescription. The canon law required the good faith in him who prescribed for all the time of his possession, and it refused to acknowledge prescription in civil cases of civil action against the possessor of bad faith. So, in a civil action, they didn't care if there was bad faith or not. The office of Chancellor in England in the medieval German Empire was the highest in the state, for the Chancellor was the Prime Minister of the King or Emperor and responsible for all his public acts. It was the Chancellor who annulled inquisitorious decrees of the King or Emperor and righted all that was wrong. And this office was usually entrusted to an ecclesiastic. In Germany, generally, to a distinguished bishop. The bishop also had a great share in the administration of justice. As in the East, also the West, and in the general superintendents over the courts. As in the East, also in the West, they had general superintendents over the courts of justice. They always had a seat in the highest tribunal. To them, the injured parties could appeal in default of justice, and they had the power to punish subordinate judges for injustice in the absence of the king. In the Middle Ages, the bishops acted likewise as judges, both civil and in criminal matters. In civil matters, the church drew its jurisdiction all things of mixed character, which were partly temporal and partly ecclesiastic, such as taking an oath. Criminal matters were brought before the bishop's court, which was held usually in connection with an episcopal visitation throughout the diocese. So each of these headings here are the different sheets that these came off of. So if you went and looked up justice on New Advent, what I'm going to show you now is a Reader's Digest version of what was on there. Justice is here taken in its ordinary and proper sense to signify the most important of the cardinal virtues. Together with charity, it regulates man's intercourse with his fellow man. But charity leads us to help our neighbor in his need out of our own stores, while justice teaches us to give another what belongs to him. Render unto Caesar what's Caesar's, render unto God what's God, render unto me what's mine. That's what Jesus said. Because man is a person, a free and intelligent being, created in the image of God, he has a dignity and worth vastly superior to the material or animal world by which he is surrounded. He is in duty bound to strive to fulfill the designs of his Creator. He must exercise his faculties and conduct his life according to the intentions of his Lord and Master. Because he is under these obligations, he consequently invested with rights, God-given and primordial, antecedent before the state, antecedent to the state and independent of it. Your rights are above anything the state can do to you. All these rights, whatever be their source, are the object of virtue of justice. Justice requires that all persons should be left in the free enjoyment of all their rights. A claim of justice or a right, in the strict sense, is a moral and lawful faculty of doing, possessing, or extracting something. The largest class of rights which justice requires we should render to others are rights of ownership. Justice between man and man is called individual, particular, or commutative justice because it is chiefly concerned with contracts and exchange. Justice requires that all should have what belongs to them, and so the just man will render to the society or state, or which he is a member, what is due to it. The Catholic Church, founded by God himself, is a perfect society and independent of the state. She has her rights, God-given and necessary for the attainment of her end, and justice is violated if these are unwarrantably interfered with. So if you want to belong to the society of Jesus, right, well, then you have to give them a tithe. If you want to be part of the state, well, they're going to come take their tithe. But what is a Catholic Church? So the definition of Catholic, of or involved in the Roman Catholic Church, of or relating to the Universal Christian Church, of or relating to the ancient undivided Christian Church, of or relating to those churches that have claimed to be representatives of the ancient undivided Church. Roman Catholic Church is a sect of the Catholic Church. No different than a Methodist. Just another name. If you've been baptized and your church uses the Apostles' Creed as part of its worship, you are a Catholic. The Catholic doctrine of justice will be found one of the main safeguards of order, peace, and progress. With even balance and equally favors all and presses unduly on none. It gives the state ample authority for the attainment of its legitimate end, while it effectually bars the road to tyranny and violence. But remember, there is no state. Nobody's taken a constitutional oath. There's no civil government. The faithful, those who have bound themselves to a religious association whose doctrine they accept and into whose rites they have been initiated. Among Christians, the term is applied to those who have been fully initiated by baptism and, regularly speaking, by confirmation. Such have engaged themselves to profess faith in Jesus Christ, from whom they received it as a gift. Henceforth they will proclaim his teachings and live according to his law. Hence the term so frequent in papal documents, the faithful of Jesus Christ. But what is ecclesiastic jurisdiction? Is the primary sense does not signify jurisdiction over ecclesiastics, but the jurisdiction exercised by the church leaders over other leaders and over the laity. So it is used to express the territorial or other limits of ecclesiastic, executive, or legislative authority. Here it is used as the authority by which judicial officers investigate and decide cases under canon law. Interesting. The jurisdiction exercised by church leaders over other leaders, heads of state, and the laity, those that believe in Jesus Christ. Such authority, in the minds of lay Roman lawyers who first used the word jurisdiction, was essentially temporal in its origin and its sphere. The Christian church transferred the notion to the spiritual domain as part of the general idea of the kingdom of God, focusing on the spiritual side of man upon earth. It was viewed as also ordained of God, who had dominion over his temporal estate. Okay, so it's all God's property. So the Christian church is going to have jurisdiction over it. The spiritual side of men on earth and all of God's property. Before its union with the state, its power in this direction, as in others, was merely over the spirits of men. Coercive temporal authority over their bodies or estates could only be given by concession of the temporal ruler. So this is before its union with the state, when there was separation of church and state. The church, founded by Jesus Christ for the salvation of men's needs, like every society, a regulating power, the authority of the church, the decree, whatever that is, rejects the doctrine that Christ did not desire to found a permanent, unchangeable church endowed with authority. Jurisdiction, insofar as it covers the relations of man to God, is called jurisdiction of the internal form, or the jurisdiction of the form of heaven. Jurisdiction, insofar as it regulates external ecclesiastic relations, is called jurisdiction of the external form, or briefly, the jurisdiction, the actual power of ruling is legislative. This jurisdiction, the actual power of ruling is legislative, judicial, or coactive. Ordinary jurisdiction is that which is permanently bound by divine law or human law with a permanent ecclesiastic office. Its professor is called an ordinary judge. By divine law, the Pope has such ordinary jurisdiction for the entire church, and a bishop for his diocese. So the bishop has ordinary jurisdiction, and he's the ordinary judge. A bishop is a canonist, and a priest is a theologian. That's when you go talk to priests, they don't know anything about the frickin' law, right? They didn't get trained in it. A canonist is an expert in canon law. By human law, this jurisdiction is possessed by the cardinals, officials of the Roman Curia, and the congregations of the cardinals. All these people have got it. If, however, the jurisdiction is permanently connected with an office, but the office itself is said to be quasi-ordinary, something or other, this form of jurisdiction is possessed, for example, by a vicar general. Yeah, so they got some jurisdiction. But they're not the ordinary judge. Delegated jurisdiction rests entirely on special authorization of holders of ordinary jurisdiction, or on a general law. The Catholic Church considers has the right as a perfect and independent society. So it's independent of, like the United States of America or Germany or England. It's its own society. It's an independent society, provided with all the means for attaining its end, to decide according to its laws disputes arising concerning its internal affairs, especially as to the ecclesiastic rights of its members, and also to carry out its decision, if necessary, by suitable means of compulsion, contentious, or civil jurisdiction. This implies the right to admonish and warn its members, ecclesiastic or lay, who have not conformed to its laws, and if needful, to punish them by physical means, that is, coercive jurisdiction. The Church has the power to judge sin in the internal form, but a sin can be at the same time externally as a misdemeanor or crime when threatened with external ecclesiastic or civil punishment. The Church also judges ecclesiastic crimes in the external form by infliction of penalties, except when the wrongdoing has remained a secret. In this case, it's content itself, as rule, with penance voluntarily assumed. In other words, if you don't make it an issue, they're not going to, except when the wrongdoing has remained a secret. The Church also judges ecclesiastic crimes in the external form by infliction of penalties, except when the wrongdoing has remained a secret. Taken to the wrong court, folks. You're taken to a court that believes in the separation of church and state. Well, if the church isn't involved, that means there's no spiritual matters that can be brought forward. So oaths don't matter, contracts don't matter, nothing matters. It's a free-for-all. A last distinction is to be drawn between necessary jurisdiction and voluntary jurisdiction. The later contemplates voluntary jurisdiction on the parts of those who seek, in legal matters, the cooperation of ecclesiastic agencies, notarial executed instruments. You put a notary seal on it, the church just got jurisdiction. Wonderful. So that means if you put it on yours and somebody doesn't pay any attention to it, well, take it to the church. Hey, they're not paying attention to my instrument. Is this not a lawful instrument? The judicial power described above, jurisdiction strictly so-called, was given by Christ to his church, and was exercised by the apostles and transmitted to their successors. Again, these are excerpts, right? So I can't say everything goes one after another. I'm just reading stuff as it comes up. From the beginning of the Christian religion, the ecclesiastic judge, the bishop, decided matters of dispute that were purely religious in character. The jurisdiction of the church was recognized by the imperial power when it became Christian. So when the Roman emperor, whichever one it was, I think it was Justinian, whoever was the first one, when he became a Christian, he just gave the church public character. It was recognized by the civil imperial power when it became Christian. Beautiful. But long before this, the early Christians, following the exhortation of St. Paul, were wont to submit to ecclesiastic jurisdiction. Matters by their nature belonged to the civil courts. As long as Christianity was not recognized by the state, it was left to the conscience of the individuals whether he would conform to the decisions of the bishop or not. Once Christianity had received civil recognition, Constantine the Great raised the former private usage to a public law. Ecclesiastic law just became public law when Constantine the Great put it there. According to the imperial constitution of 1321, the parties in dispute could, by mutual agreement, bring the matter before a bishop, even when it was already pending before a civil judge, and later was obliged to put into effect the decision of the bishop. A further constitution of 331 provided that in any stage of a suit, any one of the parties could appeal to the bishop, even against the will of the others. But somebody in 398 and somebody in 408 limited the judicial competence of the bishop to those cases which both parties applied to him. And it went on with some other stuff. But, back and forth, as they're deciding what the jurisdiction is going to be. In the Middle Ages, the church succeeded in extending its jurisdiction over all matters that offered an ecclesiastic interest. All litigation concerning marriages, matter concerning burial, testaments, compacts ratified with oath, matters pertaining to benefices, patronage, litigation concerning church property, and tithes. In addition, all civil litigation in which an element of sin was in question could be summoned before an ecclesiastic court. Sin is a transgression against God's law. Right? So if you're coveting my property, or you're stealing, or you're adulterating my name, you've just committed a sin. You're bearing false witness. You've committed a sin. Ecclesiastic court has jurisdiction. Also, the ecclesiastic court had jurisdiction over the affairs of ecclesiastic monks, nuns, poor, widows, orphans, and those persons to whom civil judge refused legal redress. In regard to ecclesiastic jurisdiction in criminal matters, the church exercised jurisdiction at first only in purely ecclesiastic offenses and inflicted only ecclesiastic punishments. Excommunication, and in the case of some clerics, deposition. The observance of these penalties had to be left to the conscience of the individual, but with the formal recognition of the church by the state and the increase of ecclesiastic penalties proportionated to the increase of ecclesiastic offenses came an appeal from the church to secular arm for aid in enforcing the said penalties, which was always willingly granted. Above all, by means of some kind of privilegium, it withdrew the so-called criminos clerks from the jurisdiction of the civil courts. Then it obtained for the court held by the bishop during the diocesan visitation not only the punishment of those civil misdemeanors which involved an element of sin, punishment of those civil misdemeanors which involved an element of sin. Somebody trying to take your property, misdemeanor, and consequently affected both church and state, but it also punished, as such, purely civil offenses. The penal jurisdiction of the medieval church included, therefore, first merely ecclesiastic offenses, heresy, schism, so forth. Then were merely civil offenses, were finally mixed offenses, sins of the flesh, sacrilege, blasphemy, magic, perjury, usury, etc., etc., etc. In punishing offenses of purely ecclesiastic character, the church disposed unreservedly of the aid of the state for the execution of the penalty. When in the aforesaid ascend court held by the bishop during his visitation. So the bishop would go sit in court, and the earl would be there with him, using England as an example. And, all the cases would come to them. And, if it was not in the jurisdiction of the court, the bishop, or if it was not in the jurisdiction of the church, the earl handled it. If it was spiritual, the bishop did. And the bishop would give his rendering, and the earl would make sure whatever it was, by common law, the sentence for that was carried out. The penalty, as a rule, is enforced by the imperial court. When the sin began to disappear, both ecclesiastic and secular judges were, in general, held equally competent for mixed offenses. You can go to either one. Prevention, previous adjudication of the case by one judge or another, was decisive. In the matter were brought before the ecclesiastic judge, he inflicted at the same time a civil penalty, not, however, corporal punishment such as the death penalty. Today, the only objects of contentious ecclesiastic jurisdiction, over which, however, the state often takes part or interferes, are questions of faith, the administration of church property. So, when they bring you in for an IRS issue, they're going to say you put in a false statement of some kind. Well, that's perjury. All right, they're going to try to get you from an ecclesiastic. They're going to say, oh, we got to step in. It's an ecclesiastic issue. We better help the church out. And we're going to say it's perjury. Forget the false witness and everything else they did to get you there, right? Oh, perjury. You're the one who's to blame. As to the criminal jurisdiction of the church, it now inflicts on the laity only ecclesiastic penalties and solely for ecclesiastic offenses. If ever civil consequences ensue, only the civil authority can take cognizance of them. As regards ecclesiastics, the power of the church to punish their disciplinary offenses and maladministration of their office is widely acknowledged by the state. The maladministration of their offices. Interesting. Where the church and state are not separated, the state aids in investigating these offenses, as well as in executing canonically rendered decisions of the church. Okay, so these must have been up here, where things where the church and state are separated, which would be in the United States of America. However, if you consider yourself in the laity, well, your church and state are never separated. So now it changes things. As to civil offenses of ecclesiastic jurisdiction carries with it no secular consequences, though the church is free to punish such offenses by ecclesiastic penalties. According to the papal bull, apostle, something or other, those persons fall under the excommunication reserved to the pope, who directly or indirectly hinder the exercise of ecclesiastic jurisdiction in the external form or in the internal form. Okay, so these are going to be excommunicated. Who directly or indirectly hinder the exercise of ecclesiastic jurisdiction in the external form or the internal form, as well as those who appeal from ecclesiastical to civil jurisdiction. Finally, every legislator or person in authority who directly or indirectly compels a judge to cite ecclesiastic persons before a civil tribunal. So it sounds to me like the church is going to take jurisdiction over those kind of things too. Ecclesiastical courts. In instituting the church as a perfect society, distinct from the civil power and entirely independent of it, Christ gave her legislative, judicial, executive power to be exercised over her members without any interference on the part of the civil society. If you're part of the church, the civil society has nothing to do with you. His church is his church, as to enable her rulers to make laws regulating the faithful, conducive to the attainment of eternal happiness. I'm going to start going through this a little bit quicker. Now the infliction of punishment certainly presupposes evidence of the crime, since according to natural law, no one should be condemned until his guilt has been established. The church wants fucking proof. Excuse my French. St. Paul plainly refers to the perfect judicial procedure when he cautions his disciple Timothy not to receive an accusation against a priest except in the presence of 2 or 3 witnesses. And I think in laity you're considered a priest in the church of heaven. Finally, in the apostolic constitutions, which currently represent of the ancient practice of the church, we find that certain days are set to conduct trials. The mode or procedure and other details are so clearly set forth. For later periods, evidence abounds. So in these constitutions, it would tell you when court dates would be. In the early centuries, when Christians were still few in number, when their new faith and new moral life constrained the followers of Christ to carry out his precepts, especially the one by which he wishes them to distinguish from all men in this period, to be distinguished from all men in this period, and when they are exercised generally among the faithful, one heart, one soul, it was customary in the case of controversy arose to appear before the bishop and accept his decision. This was in accordance with the grave admonition of St. Paul, who urged the faithful not to appear as litigants before civil courts. If you're one of the faithful, don't go to the civil courts. Though in such cases a bishop often assumed the role of friendly arbiters rather than strict judges, we should not infer they never conducted a strict trial, so they can be a conciliatory. In other words, you can pick the phone up and say, hey, give the guy back his property. We've got the evidence. furnishes us with information to the point in these words address the pagans, i.e., the church is wont to warn and punish, is a divinely appointed censor whose weighty decisions are accepted as rendered in the presence of God. God's in the courtroom, in the ecclesiastic court. He ain't there in them frickin' private courts. When the Christians obtained control of the civil power of Rome, the reasons that moved St. Paul to persuade or command the faithful to avoid the civil tribunals were, of course, no longer pertinent. Gradually, the courts allowed the faithful to submit their differences either to ecclesiastic or civil tribunals. From the beginning of the new era, bishops shared with secular magistrates the power of settling disputes of the faithful. So, when there's, no separation of church and state, well, you can go to a civil or an ecclesiastic. You're going to get justice. When there is separation of church and state, you're going to get whatever they want to give you. And that's what's happening to us now. Those who have bound themselves to a religious association whose doctrine they accept and onto whose rites they have been initiated, among Christians this term is applied to those who have been fully initiated by baptism, and regularly speaking by confirmation. Constantine the Great published 2 constitutions where he not only permits laymen to have their cases tried before the bishops, but also decrees that in all cases, which until then were wont to be tried by somebody, the praetorian, by the civil law should, when once settled before an episcopal court, be considered as finally adjudicated. So, if we're being served papers from them, we want to take it to the bishop, and when he renders a decision, the case is over. And they always self-confess on their paperwork, because when they send you a summons, it doesn't have the seal of a justice on it, but it does have the seal of a clerk, and a clerk's a notary, and they just gave the ecclesiastic court's jurisdiction. Having come through baptism to the supernatural life, being members of the Christian society and adopted children of God, the laity belong to the chosen race, the royal priesthood, formed of all those who are born again in Christ. And a priest shouldn't be going to a civil court. You are a priest. They have therefore a right to share in the common spiritual goods of the Christian society, which implies a corresponding obligation on the part of the clergy to bestow on them these goods, in as far as its bestowal requires the intervention of the ministers of religion and of the spiritual authority. Well, don't they say we're dead decedents? Wouldn't it be good to get that changed? Right? If you're a member of the laity, you're part of the chosen race, the royal priesthood. I'm going to go talk to them. A private individual, for instance, could not hand down a decision, nor could he compel others to abide by it. In the case of a secular judge, his jurisdiction comes from the civil authority. It is in purely spiritual matters, the latter is powerless, since God has committed them exclusively to the church. And again, there is no civil authority. Nobody's taken a frickin' public oath. They haven't taken the constitutional oath. In this domain, the civil power has neither legislative nor judicial authority. Whatever, therefore, concerns the faith, divine worship, the sacraments, or ecclesiastic discipline is foreign to the civil order. Likewise, no persons are to be judged. Not all persons are to be judged by secular courts. The Church could not permit her clergy to be judged by laymen. It would be utterly unbecoming for persons of superior dignity to submit themselves to inferiors for judgment. The clergy, therefore, were exempt from civil jurisdiction. And this ancient rule was sanctioned by custom and confirmed by written laws. So, if the clergy is priest, and because we're part of the laity, we're part of the royal priesthood, we shouldn't be going to a civil court. They don't have jurisdiction. Tell them. Thus, in Christian antiquity, a council condemned the bishop for demanding a civil trial, and the council decreed that clerics who strive to bring their lawsuits or disputes before secular judges should be deprived of their clerical dignity and removed from their offices. So, if we're part of the priesthood and we take our stuff to a civil court, they're going to say, well, you're breaking your own Christian laws, right? So there you go. The ecclesiastical exemption was not a personal privilege. It belonged to the entire ecclesiastic body and could not be renounced by individuals. Right? If you're going to be part of the laity, all your stuff is going to be handled in ecclesiastic court. To make this clear, the author, in addition to examples drawn from certain effects of matrimony, borrows from the ancient canonists the illustration of a contract entered into by lay persons and confirmed by oath. These are things they have jurisdiction over. Here to the obligation of justice is added that of religion, and we easily recognize a twofold juridical element, bringing the matter in question, at least as far as the value of execution of the contract is concerned, within the ecclesiastic as well as civil domain. Where it is a question only of value of the oath, the matter would, of course, be purely a spiritual one. Again, they've taken oaths. They may not have taken a public oath, but they still taken an oath. If in medieval times the church exercised jurisdiction in regard to temporal concerns of orphans, widows, and other persons of unfortunate condition, no equitable mind could see therein a usurpation of civil jurisdiction on the part of the ecclesiastic authorities. Orphans, widows, and other persons of unfortunate condition. I'd say that's us. The true and adequate explanation lies in the peculiar necessity of this age, the deficient administration of justice, and the undue power exercised by the rich and mighty. Rather does it redound on the honor of the church that she then assumes the defense of the poor against the wealthy and powerful, and came to the aid of those who were deprived of all human help. So also it is obvious that not everyone possesses the judicial power in a society has once the right to exercise it upon all members of the society. So also it is obvious that not everyone possessed of judicial power in a society has at once the right to exercise it upon all members of that society. Right? They're not going to go looking for it. You need to bring it to them. It was this exigency of the common welfare that made it necessary to fix the limits of the jurisdiction of magistrates even in civil societies. We know, for instance, that in primitive Roman society there was in every district one magistrate who was supreme, who had undivided jurisdiction in the province allotted to him, but none beyond its limits. Right? So, within every district there's one judge who sits on top. The first limitation of a magistrate's power was based on territory. In later times, these principles have been retained and even partially increased and extended by our civil codes. They serve even yet to justify many special courts, the Court of Aqueducts, for commercial disputes, etc. The ecclesiastic law, cases affecting civil rulers or cardinals, or criminal cases of bishops are still reserved exclusively to the Roman pontiff. So the pontiff has got jurisdiction over civil rulers. In former times, you know why? Because they took an oath. In former times, there was a provincial council with judicial authority, in not a few cases, also a court of the archdeacon, distinct from that of the bishop, in which the courts of inferior judges, and with these, the courts of the inferior judges, whose authority was based on custom, or more generally on privilege. In place of these earlier judges, we now have vicar generals, who, however, constitute but one court with their bishop and judge delegates, representative either of the bishop or more particularly of the sovereign pontiff. So, the vicar general is under the sovereign pontiff, and the sovereign pontiff is a temporal lord, not a spiritual lord. And as a temporal lord, he hands out common law. And I think that the vicar general, right, he's basically the executor. He executes the sentence. In the 12th and 13th centuries, however, vicar generals succeeded archdeacons, and after the Council of Trent, during the 17th and 18th centuries, the archdeacon court ceased to exist. Consequently, the first ecclesiastical court is now regularly that of the bishop or his vicar general. Apparently, not every diocese has a bishop. There are some where they're empty, and so that would just fall on the vicar general. But I think if there is a vicar general, that makes him the judge of the first instance, and it says in the procedure to do a petition, you take it to the judge of the first instance. Thus, it may often happen that administration of justice in one locality necessitates proceedings in a territory of another judge. But the obligation arises not from the authority of the court requesting assistance, but by the authority of common law, which so ordains. It is evidently just, for all such courts are courts of one ecclesiastic society, the one Catholic Church, whose welfare demands that in it justice be rightly administered. Beautiful. Oh. Okay. Well, this is going to be too long. I'm not going to be able to get it all done, so I got to. Again, this will be the Reader's Digest version, and these are just excerpts out of the other pages. Lots to read, but we're talking about notaries now. They use notaries. Once you put a notary seal on it, the church just got jurisdiction. Notaries of ancient times who wrote down the Acts of the Martyrs, right? They've been around forever. And these are different kinds of notaries. You got an auditor, the title of assessor, a guy called a physical promoter. Since he plays an important part, especially in criminal cases, he rather takes the place of an accuser or public prosecutor. He could also be called the promoter of justice. Excellent. 4 chief titles by which the accused party comes under the jurisdiction. Residence, of domicile, and contract. There's 2 of them. Residence or domicile, contract. The jurisdiction of the church extends over the entire world. A person who makes a contract in a certain place thereby acquires right of a forum in the same place. And there's 2 ways they can do it. There's an extraordinary and a summary. An extraordinary is, a long drawn-out affair. And a summary is you pick up the phone. The modern civil codes, a private citizen can oblige his fellow citizen to present himself before a judge for the examination of a case. Right? So that's what they're doing to us. They're using a modern civil codes, a private citizen, the attorney, can oblige you to show up to court. Though found in the Roman law of the 12 tables, the canon law does not recognize in the private individual any such right, and holds to the later procedure of Roman law that dates from confirmed by the laws of Justinian. According to this procedure, the summoning of an accused implies power of jurisdiction and must therefore proceed from the judge himself. In their summonses to us, a judge never seals it. It's a private individual bringing you to court into a civil law court run under old Roman law where they had slaves and shit. Okay, and this is just kind of the way that the thing goes. Promise under oath to speak the truth is never dispensed with. Beautiful. Summary proceedings are commonly entered upon for 1 or 2 reasons, either because the case are such nature as demand prompt settlement, alimony, or necessary support. If you need some money, that's where you're going to. And many cases of ecclesiastics, e.g. elections and offices. Right? Again, these people are holding ecclesiastic offices in these ecclesiastic societies that believe in separation of church and state. That's just their religion. In all these cases, the judge is allowed to base his sentence on evidence somewhat less conclusive than would be called for in cases of greater importance. Summary procedures now frequently employed in criminal cases of clerics. Summary execution. Send in the vicar. And who has that power? In this congregation of propaganda extended its use to the bishops of the United States of America. Well, they have it. Influence of canon law or Roman law. Yeah, there was that. Roman law, only strictly legal suit was open to a person despoiled of his goods. The canon law allowed him the additional plea of equity. In addition, in the Roman law, suits lay only against the despoiler or the one ordered or approved the act, whereas in canon law permitted the entire suit against any third person found in possession of the plaintiff's goods, whether such detention was in good faith or not. If they find your stuff in the hands of a third person, they're going to go get it for you. Ecclesiastic judge. Every such court consists of at least two sworn officials, a judge who gives the decision and a clerk of the court. The chief duty of the conservators is to represent the rights of its members of orders, the poor, widows, and orphans. Right? You're a member of an order, right? You're a high priest in the laity. Ecclesiastic jurisdiction is exercised over all baptized persons. There's also domicile by operation law, legal fictions, fictitious, legal or fictitious domicile. From the beginning, the bishop was the judge of the first instance for all suits. The diocesan bishop or his representative, the vicar general, so forth, is now a judge at the court of the first instance. Notary, persons appointed by competent authority to draw up official authenticated documents. The ordinary notaries of the chancery, however, were gradually known by other names. In most civil courts, there are, however, called registrars, clerks of the court, but in ecclesiastical tribunals, they retain the name notary. So even in these civil courts, right, if they're a registrar or clerk of the court, they're a notary, and their oath is held by the bishop, as somebody found out some time ago in one of the calls I did. Those who are appointed by the proper authorities to witness documented proceedings between private persons to impress them in legal authenticity. Right? That's what a public notary is. Consequently, public notaries may be appointed only by those who have authorities who possess jurisdiction and have a chancery. Popes, bishops, emperors, reigning princes, and of course only within the limits of their jurisdiction. Sanctifying grace is a supernatural gift of God to intellectual creatures for their eternal salvation, whether it later be furnished and attained through solitary acts or a state of holiness. Eternal salvation itself consists in heavenly bliss resulting from intuitive knowledge of the triune God, the Father, Son, and Holy Ghost, who to the one not endowed with grace. Okay, justification, the preparation for sanctifying grace. Derives its name from justice. Not merely meant the cardinal virtue, the rights of others, the whole interrelation of man to God and a supernatural end. And it's called the act of justification. The state of habitual holiness and sonship God begins. Okay. Protestantism maintains that this faith, exclusive of good works, is sufficient for justification. Here is what's going on. A Catholic believes that it takes faith and good works to get in the kingdom of heaven. Protestantism believes it only takes faith. It has nothing to do with good works. As with a mantle of grace cover our sins, which still continue to exist internally, in the infallible, certain belief that God, for the sake of Christ, will no longer hold our sins against us. That's what a Protestant believes. So he can go ahead and rape, pillage, and plunder on the earth as long as he says, hey, I'm sorry, God, on his deathbed. He thinks that'll get him in the kingdom of heaven. Right? So, that's what a Protestant is. This is the Protestants taking you to court. I'm sorry. Right? If you believe that it takes faith and good works to get in the kingdom of heaven, and the other people believe it just takes faith, screw the good works. I can do whatever the hell I want because it's going to cover our sins, and sins are transgressions of God's law. Right? It's breaking the commandments. That's what they're saying, that they can break the 10 commandments at will as long as, before they die, they say, well, I believe in Christ and, forgive me. That's why the Jesuits hate them. A firm belief in all the truths contained in the Apostles' Creed, right? To make public recitation of the Apostles' Creed strengthens this view. Goes on and on. So, I only have a few minutes left, so I'm going to end this here, and I'm going to do another video that will have the petition I did, and what I based it on and so forth, and or one of the petitions I did. I just sent it out today to the bishop here in Grand Rapids. So, I'm not trying to pick on anybody's religion at all. And I'm not going to say there aren't bad Catholics. I'm not going to say any of that. I'm just saying what this says is an ecclesiastic court is available to you, and everything will be under oath, and you can petition them, and it doesn't cost anything to bring in a damn court case. It's just a petition. Very, very simple form. Here, I'll show you what one looks like. All right, a brother sent me this. He found this out, and oh, come on, baby, open up. Procedure for conciliation and arbitration. Petition respondent form. Right? Now, people might think, all this stuff has to do with marriage. Well, that isn't what it says. It doesn't say anything about marriage on here. But you put the name of the petitioner, the name of the respondent. Please state the issue which you are in dispute. Briefly describe the circumstances surrounding the dispute. What steps have you taken to resolve this dispute? What is your expectation of conciliation? Sign it. You're done. That starts a court case in an ecclesiastic court. Right? If you have evidence and and justice is on your side because you're right, because a banker has not given you good faith, or an attorney has brought something against you bearing false witness, how much simpler could it be? Whether it works now, we'll find out soon. I'm doing one myself, but I'm basing it on the things I'm showing you right now. And enough on that. I'm going to shut this one off, and I'll have to do another one. See you in a bit. I forgot how to turn it off. Forgot how. Well, it's over.